Can a defendant be saved from a criminal conviction if he didn't know his conduct was illegal? Normally, the answer is no. Ignorance of the law isn't a defense to a crime. Ratzlaf v. United States interprets a federal statute as making an exception to the usual rule. At a Nevada casino, Waldemar Ratzlaf lost big at blackjack. A week later, Ratzlaf returned with $100,000 in cash to repay the debt. The casino informed him that it would have to report the transaction to state and federal authorities. As part of a federal statute popularly known as the Bank Secrecy Act, Congress mandated that banks and other institutions report domestic cash transactions exceeding $10,000. But the casino noted it could accept a cashier's check for the full amount without triggering a reporting requirement. Ratzlaf left to get a cashier's check. The banks informed Ratzlaf that they had to abide by the same disclosure requirements. So Ratzlaf visited bank after bank and purchased multiple cashier's checks, each for less than $10,000. He gave the checks to the casino. Ratzlaf was charged with willfully structuring a transaction to avoid the bank's reporting obligation. At trial, the district court instructed the jury that willfulness meant merely a purpose to avoid the bank's reporting obligation. Ratzlaf was convicted. He appealed, arguing that the statute didn't merely require a purpose to evade reporting. Rather, he claimed that the statute required knowledge that structuring a transaction was illegal. The Ninth Circuit rejected Ratzlaf's interpretation of the statute and affirmed his conviction. The Supreme Court granted cert.